Hello, everyone. Welcome to our webinar. With this webinar, we want to explore key similarities and unique attributes of various jurisdictions. These include the US, the UK, Ireland, France, Belgium, and Switzerland. Our panel and attendees are scattered throughout the world. Therefore, depending on where you are at this moment, good morning, good afternoon, or good evening. My name is James Coleman. I'm an associate at the Chicago-based law firm Goldman, Ismail, Tomaselli, Brennan and Baum. I'm originally from Ireland, but moved here to the US about 8 years ago. My practice includes international and domestic commercial arbitration and litigation, as well as products liability and mass torts. We at Goldman Ismail are delighted to have partnered with the Silicon Valley Arbitration and Mediation Center, as well as Arbitration Ireland, to host this event. We have six amazing panelists to speak with you today. These include Michael Collins. Michael, unfortunately, has not been able to join yet because he is in a virtual hearing in Ireland. Michael is a senior counsel at the Bar of Ireland. He is one of the leading practitioners in Ireland, particularly with regard to commercial competition and EU law. Michael is not only a member of the Irish Bar, he is a member of the New York Bar, the Bar of England and Wales, the Bar of New South Wales, and the Northern Irish Bar. Michael is also a graduate of my alma mater, University College Dublin. He's a graduate of University of Pennsylvania. Michael began his career in New York in the early 1980s before commencing practice at the Irish Bar. Sarah Reynolds is the CEO of the Silicon Valley Arbitration and Mediation Center. She's also managing partner of Goldman Ismail, Tomaselli, Brennan and Baum. Sarah represents technology and pharmaceutical companies before domestic and international arbitral bodies, including the ICC, ICDR, AAA, JAMS, WIPO, HKIAC, and SIAC. Sarah is a fellow of the Chartered Institute of Arbitrators and is a Center for Conflict Resolution trained mediator. She is a graduate of the University of Chicago, and Sarah is also a member of the California and Illinois bars. Claire Morel de Westgaver is a partner in the London office of Brian Cave. Claire is admitted in England and Wales, New York, and the Dubai International Financial Center court system. Claire has a mixed common and civil law background, having completed her legal education in Belgium and in the USA. She is a graduate of Northwestern Law here in Chicago and the Catholic University of Louvain. Claire practices international arbitration as counsel, as advocate, and as arbitrator, and conducts proceedings in both French and English. Dorothy Schramm is a partner in Sidley's Geneva office. Dorothy is admitted in Switzerland and is a graduate of the George August University of Göttingen and the University of Lucerne. Dorothy has particular experience in technology, engineering, and life sciences, including pharmaceuticals, medtech, and biotech. She is a member of the executive committee of the Swiss Arbitration Association and is a member of the international advisory boards of the Vienna International Arbitral Center. Philippa Charles is a partner and head of international arbitration at Stewart's. Philippa specializes in complex and high-value cross-border arbitration disputes and has 20 years experience of proceedings before the major arbitral institutions. Philippa has acted for clients including major global corporations in the aviation, pharmaceutical, power, and oil and gas industries. She is a solicitor advocate and also sits as an arbitrator. Her experience includes cases seated in England, France, Sweden, the United States, the UAE, and Nigeria, as well as application of foreign laws, including those of Venezuela, Brazil, China, New York, and Russia. Philippa was born and raised in Dublin and educated in Dublin and Oxford. Alexander Blumrosen is the founding partner of the Paris law firm Polaris Law, specializing in the international commercial business disputes before courts and arbitral tribunals, with particular experience in technology, IP, and cross-border privacy. Alex is frequently named as arbitrator in institutional and ad hoc arbitrations, is appointed Hague Commissioner and Privacy Monitor by US courts under the Hague Evidence Convention of 1970, and is selected as an expert on French law and procedure in US litigation. Alex has been appointed by the EU and the US to sit on the Privacy Shield arbitration panel. A graduate of Dartmouth College, Georgetown Law School, and the University of Paris I, Panthéon-Sorbonne, he is admitted to the bars of New York and Paris. Alex is a life member of the Council on Foreign Relations and has been named as a Chevalier or Knight in the French Legion of Honor. We're going to jump in with quite a general question to get the discussion started. And I'm going to start with Alex. Alex, could you outline some of the benefits of France and Paris in particular as a seat for international arbitration for contracting parties?
Sure. Thank you, James. Glad to, and thank you for having me on this panel. I will go very quickly through a short list. The first is that there are expert institutions in Paris. We have the International Chamber of Commerce, the ICC. We have the local French Chamber of Commerce, which is called the CMAP. And there are several others, all of whom have expert secretariats that know their way around arbitration, that can advise the parties, and that prepare the final awards that issue from the institutions to make sure that they hold up under scrutiny of the courts. So that's one. Second, there are specialized French courts in arbitration, both at the commercial first instance level, the Tribunal de Commerce and the Court of Appeals, where you can argue in English. This is fairly new. These courts have been around only for 3 or 4 years. And they are actually very efficient and effective ways to get your English language arbitration done in France, enforced in France. The third is what the French would call the negative effect of the arbitration clause. And this is a little bit similar to the competence issue that we will come back to, I believe. And this means that the courts, if they are confronted with an arbitration clause, will let the arbitrators decide their own jurisdiction, will let the arbitration proceed, and the courts have a limited role in intervening in the presence of an arbitration clause. And finally, I would just say that this I suppose is the fourth, that there is very limited review of the merits or scrutiny of the merits of an arbitration award upon enforcement in France. So those are my main takeaways for France.
Thanks, Alex. Dorothy, I'd like you to address the same question. What are the benefits of Switzerland as a seat for arbitration? Why should contracting parties decide to arbitrate there?
Well, I would say 3 keywords: neutral, international, and efficient. Now, neutral, I mean, Switzerland is absolutely known all over the world for being a politically very neutral and very stable country. And that's normally what people are looking for when they're looking for a venue to resolve their disputes. And I mean, it's long-standing. It's more than 150 years of history as a neutral seat of arbitration. And that is pretty much up at the top there. And when I say international, I mean, I'm talking about the community, for example. We have really experienced and very specialized arbitration practitioners from all over the world that are practicing in Switzerland, both from common law countries and civil law countries. And then you couple that with a very liberal arbitration act that also allows for civil law and common law approaches. And you can even file your challenges against arbitral awards in English. So very internationally minded. And then in terms of efficiency, now efficiency is really something that gets drilled into your head if you practice arbitration in Switzerland. And I think you see that in terms of data points reflected in the fact that, for example, the challenge proceedings against awards are typically an average done within like 6 or 7 months. And that's pretty unrivaled amongst the seats of arbitration. And that's just, a data point. That's one example.
Thanks, Dorothy. I see now that Michael Collins was able to join us. Michael was delayed because he had a virtual hearing. Michael, I've been asking the other panelists about why contracting parties should choose their jurisdiction as a seat for arbitration. What are the general benefits? We hear a lot about Paris and London and Geneva as big international arbitration centers. But why, in your opinion, should parties now look to Ireland, a significantly smaller jurisdiction, as the seat for arbitration?
Hi, James. Yes, I just caught the end of what Alex was saying about it. And of course, in Paris, perhaps the advantage that he has identified that you can have your case heard in English, but of course, English is a native language in Ireland. So you can have your arbitration heard in English, no problem at all in Ireland. More seriously, I think one of the One of the primary reasons I think is that, firstly, we've adopted the UNCITRAL model law. We have an exceptionally well-qualified judiciary who are dealing with arbitrations. In fact, we have a dedicated judge in the High Court who specializes in arbitration and deals with them. And I mean, unlike, for example, the English Arbitration Act, when you get your arbitration award, there is only one level of appeal or review, I should say, possible to the court. The dedicated arbitration judge entertains whatever the review is that's sought to be made in relation to it, and that's the end of it. There's no appeal to the Court of Appeal, there's no appeal to the Supreme Court beyond that, so that what you have in other jurisdictions, an endless process of strung out litigation that really defeats the essential purpose of what arbitration is supposed to be about. It's supposed to be a kind of a one-stop shop that is providing a dispute resolution mechanism for people with some minimal level of court review. And that's exactly what we have in Ireland. We've also got, if I may say so, I think we've got very, very good lawyers who can participate and do participate in international arbitration. And they have increasingly made their mark in recent years. And perhaps finally, or penultimately at least, the fact of Brexit means that Ireland is now the only common law, exclusively common law jurisdiction left in the EU. And Malta and Cyprus have an element of the mixed systems of common law and civil law. And that is particularly attractive, particularly for people from a common law background. If there's a dispute between a US company and a UK company, for example, both of those jurisdictions have a very warm regard for Ireland. They both regard Ireland almost as another home venue, practically. And it becomes very attractive. And the last reason is, of course, simply the sheer pleasure of coming to Ireland and being able to conduct your arbitration in such nice surroundings as we have in Ireland.
Michael spoke about the quality of Irish lawyers, so I want to point out that 3 of us are from Ireland on this panel today, and Sarah's parents are from Ireland. So I think we're overrepresented probably on this panel. So turning to Philippa, who's from Dublin but practices with Stewarts in London. Philippa, what are the benefits of London as a seat for arbitration? I know for many people attending, London is the go-to seat.
Well, and it may be, but actually I think London definitely has some competition, because listening to my co-panelists, there are aspects of their respective seats that are in fact deeply attractive. I think what makes London a popular destination is the degree of predictability that I think people think there is, both in the treatment of arbitration generally, the fact that there's a very strongly pro-arbitration bias in the courts, and therefore that if you have an agreement to arbitrate, it will be upheld, it will be recognized. And although there is more level of review, I suppose, available than that which Michael has laid out in a pure model law territory, the attitude of the English courts is by and large a hands-off approach to the conduct of arbitration. And really it's only in exceptional cases that you will find interference, albeit that the mechanisms are there. And I think sometimes, and this is always the concept of, you'll want a review mechanism if you're at the wrong side of the award. But the fact that it exists at all, I think, provides some measure of comfort to parties who may feel at risk, particularly in an ad hoc scenario or a trade arbitration scenario where there isn't a level of institutional involvement or supervision in the way that one would have with, for example, an ICC arbitration. And then in common with the other big jurisdictions, we have an excellent depth of practitioners, including a lot of international practitioners, which I think is a benefit and does provide support to clients. And finally, I suppose just English law itself, the mother common law in some ways, I think it's still a very popular contracting choice, particularly for parties from other parts of the world who simply can't agree on something that's mutually acceptable. I've done cases with Brazilian parties on one side and Chinese on the other, and the law they were able to agree to apply was English. And that, I think, remains a key benefit to London as a place to arbitrate.
Claire, You primarily practice in London as well, but given your background being from Belgium and having studied law there as well as in the US, can you outline the benefits of Belgium as a seat for arbitration?
Sure. So I think you all know that Belgium is in Brussels is really at the crossroad of Europe, and that means that there's a lot of company, major companies and organizations that are headquartered there, including of course the EU and NATO. That means that that makes Brussels extremely cosmopolitan, and also diverse in terms of the bar, arbitration practitioners. We have major, very renowned arbitrators coming from there. Brussels in Belgium is also kind of regarded from a business point of view as also neutral, politically maybe less neutral than Switzerland. And so that makes Brussels quite attractive to resolve cross-border disputes. In terms of the law, the Belgian law is based on the model law. It's a very predictable and secure jurisdiction. We also have the CEPANI in Belgium, which I think is a testament to Belgium, becoming increasingly attractive to international stakeholders to resolve disputes there. It was founded in 1969 by the National ICC Committee and also the Federation of National Enterprises. And its caseload is really growing year by year with more and more fully international cases. There's also a fair amount of cases sitting in Brussels that are conducted under other rules, mainly the ICC rules, but others as well. Another very good selling point for Belgium is of course it's a pro-arbitration stance, from a judiciary point of view, but also from an arbitrability point of view. Very few disputes are not arbitrable under Belgian law. A quite well-known example of that is arbitrability of IP disputes. In Belgium, for example, validity of IP of patents is arbitrable, and a decision by an arbitral tribunal on the validity of a patent, including invalidity of a patent, will have effect beyond the parties to the proceedings. So will have effectively erga omnes effect. Can be a tribunal award, an arbitral award can be registered at the patent office. So just to give you an example of the broad scope of disputes that can be arbitrated under Belgian law.
It's the same in Switzerland, actually. Belgium and Switzerland, I think, are one of the few jurisdictions where you can do that, where you can register the award straight in the patent register.
Okay, and finally to Sarah. Sarah, can you tell us generally what the benefits of seating your arbitration in the US are, as well as perhaps more specifically the benefits of seating an arbitration in Chicago and Illinois, which is the home place of our law firm, and in California, which is the home of the Silicon Valley Arbitration and Mediation Center?
Yeah, happy to. I wish we could say we had as liberal of an IP policy in terms of enforcing patent arbitration awards, but it is much clearer what you can do in arbitration in the US than it was in the past, but you still can't arbitrate whether or not an invention is patentable. That still has to go to the patent office. But despite that, I think we do have lots of good things to say about the US. Obviously, the US is comprised of a number of jurisdictions, federal and state, but with the Federal Arbitration Act, that really ensures consistent results across jurisdictions, particularly when you're dealing with commercial issues. Preemption essentially applies to erase inconsistencies among between states. We also have a very liberal policy among our domestic courts in support of arbitration. So outside of employment and consumer contexts, you know, in any sort of commercial context, courts are going to be leaning heavily in favor of both enforcing agreements to arbitrate and enforcing awards. Only very limited grounds upon which you can validate an arbitration award in the United States, and those grounds are construed very narrowly by the courts. In addition to that, we have a sophisticated pool of experienced arbitrators, both arbitrators, arbitration counsel, and judges, you know, a sophisticated judiciary that have dealt with arbitration issues. In terms of our arbitrator pool, it's also increasing in diversity, which is really good to see. Even in the last, you know, 15, 16 years that I've been practicing, I've seen phenomenal increases on that front. And so, you know, in general, in the United States, you're well positioned, particularly with respect to commercial disputes. A more careful analysis would be required for consumer and employment context, but on the international arena, we're usually dealing with commercial parties anyway. And then I won't compete. We have formidable opponents here to compete with in terms of world-class cities and great places to arbitrate, but you know, we have several world-class cities in the United States that are well set up for arbitration logistics and hearings.
So Alex mentions the doctrine of competence, and that doctrine, with its origins in German law, provides that an arbitral tribunal has jurisdiction to consider and decide any disputes regarding its own jurisdiction, subject to, in certain circumstances, judicial review. Of course, all of these jurisdictions have different rules and jurisprudence regarding when the courts are going to get involved, both in interim measures and in reviewing awards. I'm interested, Philippa, in how the UK, under the Arbitration Act 1996, deals with appeals, because I think it is broader than some of the other jurisdictions. For example, how can parties go about appealing cases involving arbitration in the UK?
Sure. Look, there are three routes available in principle under the Arbitration Act to challenge an award. So Section 67 of the 1996 Act, which deals with challenges based on the lack of jurisdiction of the tribunal, which can be raised on any available basis that properly goes to the question of jurisdiction. There's Section 68, which relates to serious procedural irregularity. And whilst that sounds like an open goal for challenges based on any and all procedural misconduct, in fact, the statute lists a restrictive number of bases on which a challenge under that section can be raised. And it's fair to say that Section 68 challenges are so unsuccessful, I've begun to suspect that there's a private policy in the English courts to reject all such applications. I think there's less than 1% of all cases under Section 68 are ever successful these days. So it's a very difficult bar to surpass. And then the third route is Section 69 of the Act, which provides for appeals on a point of law. So in other words, if the tribunal's got the law wrong. But the issue with Section 69 is that it is a non-mandatory section of the 1996 Act. In other words, you can contract out of the ability to bring a challenge under that provision. And by signing up to most of the major institutional rules, so in other words, if you have an ICC arbitration, you will have signed away your statutory option to pursue an appeal on a point of law in England. So the reality is that although it is in principle a broad array of routes to challenge an award, the reality is that there's very little success. In fact, in the English courts, which goes to the point I made earlier about the pro-arbitration stance of the courts. But it's certainly an unusual set of circumstances, and not necessarily one that I think non-English parties would necessarily be aware of in terms of the level of restriction that's placed around the ability to challenge.
We may come back to this further later, but I understand that the Law Commission of England and Wales is looking at reforming the Arbitration Act of 1996 after seeing 25 or 26 years of jurisprudence under it. Given what the judicial hesitance you've talked about regarding appeals, do you expect that appeal regime to change?
It might. There's certainly a lot of debate at the moment as to how best to revisit the Arbitration Act. I think there's a lot of it that's working extremely well, and if it ain't broke, don't fix it, as they say. But there are aspects of the differential nature of the statute which I think do open it up to consideration for review. And I certainly think one of those aspects is in relation to the appeal rights and the extent to which courts are going to be empowered or disempowered from interfering with arbitral outcomes.
Sure. Michael, you talked about the system in Ireland, and it seems to be quite more limited than in the UK when it comes to judicial intervention. You mentioned that there is an arbitration judge. Can you tell us more about that position?
Yes, it's not a formal statutory position. It's more a matter of administration by the President of the High Court, who allocates judges to different divisions and different tasks and responsibilities. And when we enacted the 2010 Arbitration Act, which adopted the unstructural model law with very few amendments, a number of us who were interested in the area made representations to the then President of the High Court that he should appoint a particular judge who would deal with all arbitration, reviews, appeals, jurisdiction challenges, whatever it might be, interlocutory injunctions, discovery, security for costs, and so on, so as to build up the necessary expertise in a judge. And that's particularly important in a small jurisdiction like Ireland, where we have a much smaller number of judges, for example, than in England or many other, and certainly the United States, and where the number of actual cases that go to court in arbitration, although surprisingly large actually when you look at them, but they're certainly smaller than in other jurisdictions. So it made sense to concentrate the expertise in one particular judge, and that until very recently was Judge Barneville, who has given therefore most of the arbitration decisions in Ireland in the last number of years. And I mean, he has been a very pro-arbitration judge, but also, interestingly, he is very receptive to looking at authorities from other jurisdictions, and particularly to see how other courts have dealt with issues that may not yet have been determined in the Irish High Court. For example, a couple of years ago, there was a dispute over whether an arbitrator had jurisdiction to deal with the full scope of the claim that was before her. She held she did. An application was brought under Article 16.3 of the model law to challenge that decision effectively. And Judge Barneville held that he had a full de novo entitlement to review the jurisdiction, again, following the authorities to that effect in other jurisdictions, but there just hadn't been a case in Ireland where that point had been decided. So while there's nothing remarkable about the decision in the sense that it's very consistent with other common law jurisdictions, it's a good example, I think, of how a dedicated arbitration judge who's alive and alert to what's going on in the arbitration world can make a big difference.
We were lucky enough last year to have, or perhaps maybe it might be the year prior now, to have had Justice Barneville as a panelist on one of these webinars, and his decisions are definitely required reading for anyone with an interest in arbitration in Ireland. Claire, I understand that in Belgium one can waive rights of appeal in arbitration cases. How does that work?
So yeah, maybe good to compare that position with the Arbitration Act. So as Philippe said, there's only a few, the appeal on the law that parties can waive in England. In Belgium, there is also a possibility to waive any procedural challenge. So effectively, annulment proceedings can be waived, but that's only if none of the parties to the arbitration agreement is connected to Belgium. So if the parties or either parties connect to Belgium, that's not possible. But if they're effectively choosing Belgium, Brussels as a neutral place, and they're not connected, then they can waive that procedural right to annul an award, and that's Article 1718 of the Belgian Judicial Code, if you're interested.
Great. Turning to Alex, I know with judicial intervention, there have been some really interesting developments in France in the last couple of months regarding judicial interpretation of independent and impartial. Could you tell us a little about the Bellicon and the Santolo-Sericom decisions?
Yes, well, maybe I can put these into the context of what we were just discussing about appeals. Just to give you this context under French law, which is that there is a serious distinction between domestic arbitration and international arbitration in French law. And in international arbitration, which is defined as any arbitration that affects the interests of international commerce, there is far less judicial intervention. So while in a domestic arbitration, you can have an appeal of an award and an initial court determination, in France, there is no appeal per se. You go initially with your arbitration award to the Court of Appeals, skipping that first instance court to get enforcement. And at the Court of Appeals level, they will review de minimis, looking only at public policy and due process concerns. There is no review of the award on the merits. And this is a longstanding principle of French law, that the reviewing court will not look to the merits of the dispute, will not review the fundamental decisions of the arbitration panel, whether it's on issues of fact, on issues of law, but they will look to issues of public policy, fraud, illegal or fraudulent forum selection questions, and rules of international public policy as defined in France. Now, up until very recently, those issues of international public policy that allowed the Court of Appeals to intervene and to review and to scrutinize an award were quite limited. And what we've seen in the last 3 to 5 years is that in certain areas, in particular where there are allegations of corruption of the arbitration process, and issues of the impartiality of the arbitrators, and considerations that there were too close ties between the arbitrators and counsel appointing or the parties, the Court of Appeals will take a much more active role. So in these 2 cases you mentioned, the Bellicon case, there were allegations of corruption. And because of those allegations of corruption, the Court of Appeals did an interesting thing. They maintained this longstanding tradition of saying that they will not review the merits of the case. And they did not. They don't look at the exchanges of the arbitrators. But what is interesting is that they go even beyond what the exchanges were in the arbitration process, in the arbitration, to the entire context of the dispute resolution process. And so they they'll look at how the parties came to arbitrate, what the interests were in the arbitration process. In the Bellicon case, there was a long and tortured history that I won't bore you with, but without looking at the award itself, but at the history and the context of the arbitration process, the court, both the Court of Appeals and the Supreme Court, which affirmed, saw that there were simply illegalities, fraud, violations of public policy, corruption in connection with how the parties got to the arbitration itself. And it was on that basis that the court said, well, we're not going to enforce this. We can't condone this. We're not going to look at the substance of what the arbitrators decided, but the entire arbitration process has been tainted by corruption. And so we will not allow, in an enforcement or an annulment context, for a tainted arbitration award to be enforceable in France. So we need to be very careful when we look at arbitrator impartiality and corruption, because those are two areas where the French courts take on a new kind of a standard of scrutiny that they never have before.
And that's pretty interesting. I'm wondering if any of the other panelists want to jump in about how that might be handled in their jurisdictions. And does anyone think that courts elsewhere, particularly courts in other jurisdictions that are loosely based on French civil law, will end up following suit and adopt a similar standard? No takers. Or Alex, given your additional experience as a US qualified attorney and your other experience in many other jurisdictions throughout the world, do you think other places are going to follow suit?
Well, so there are two questions that have been raised. One is a domestic French question, which is, will the Supreme Court end up extending this kind of advanced scrutiny that they've used in these two areas to other areas as well? And there is some debate about this. It's mostly the commentators who are undecided about which way the courts are likely to go. Personally, I think that they will stay with this carve out of two significant issues, impartiality and corruption, and will not extend more advanced review to other areas, in part because France has such a long tradition of pro-arbitration bias and leaving the arbitrators do what they will and not scrutinizing awards, that any extension of this new principle is likely to endanger that. And so there's a real pull, because obviously the courts do not want to allow tainted arbitration awards into France, but they want to keep Paris as an attractive location for holding arbitrations and for enforcing arbitration awards. And so they're walking a very tight line. Now, as to whether they will, that other countries will start to adopt this, I think they may. It does run counter to the longstanding international tradition of limited scrutiny. But in many cases, France has been a leader. The French Court of Appeals in Paris and the French Cour de Cassation has been a leader in arbitration law matters, obviously in French law, but many of their decisions about enforceability and international public policy have been adopted by other jurisdictions. And in many cases, French case law actually goes beyond the New York Convention and makes arbitration awards even more enforceable under French law in France than they would have been under the New York Convention. And in some circumstances, other countries have followed suit, creating more pro-arbitration environments to make their jurisdictions more attractive. So I think this is, in the context of current issues of corruption, a very important and significant step. The Supreme Court in the Belgian issue, in the Belgian matter, referred specifically to the OECD corruption treaty, anti-corruption treaty of 2003, as one of the bases for the extension of this kind of scrutiny. And I think that was really a call by the French court to other jurisdictions to say, this is a question of international public policy for everyone, and that we should all be on the same page. So on those two issues, and especially on corruption, I think we will see a growing movement in this direction. I'm not sure if the other panelists agree.
Right, and I'm now a little conscious of time, so with apologies for jumping around topics a little bit, I'm going to talk about another big development that isn't just in France, it's worldwide, and the effect of COVID-19 and changing technology on arbitration. And I'd like to ask Dorothy, regarding Switzerland, how changing technology has affected arbitration. I know from personal experience trying to deal with depositions in Switzerland that it can be difficult doing things virtually sometimes if I'm understanding things correctly because of the rather strict rules there. And I'm wondering how this has affected arbitrations seated there.
Well, to cut a long story short, it hasn't really affected arbitration. If anything, it has made it more popular. I mean, you know, arbitration was generally, not only in Switzerland, much better equipped to deal with the restrictions posed by COVID-19 in that, you know, I mean, electronic proceedings or having the hearing remotely in particular is, of course, was not a problem in Switzerland. In Switzerland, there is no right to a physical hearing. So in Switzerland, it could be adopted very quickly. And so that's why, you know, in Switzerland, Swiss-based arbitrations were not affected, whereas the state courts in Switzerland and elsewhere, they were all struggling with, okay, the courts, the judges can't physically go to work, or they don't have the files at home, they don't have sometimes even access to the, you know, secure IT environment. And there's a big backlog now that the courts are fighting with. And all of that was never an issue in arbitration. So arbitration itself unaffected in Switzerland, and also the setting aside is unaffected in Switzerland because in Switzerland, the challenge against an award goes to one single instance, and that's straight the Swiss Supreme Court. So there's a specialized panel of the Swiss Federal Supreme Court that decides all the 50 or 60 challenges of arbitral awards, or even sometimes more per year. And those proceedings are very fast, and they're typically without a hearing. So also there, the judges, they decide basically on the basis of the written submissions. And that's why also the setting aside wasn't really affected. So all in all, I must say, in Switzerland, in arbitration, we haven't felt almost anything about arbitration, about COVID-19, other than that thankfully, you know, video conferencing and hearings by video have become standard. And so at least we have now one more option of doing things in certain cases if it's appropriate.
I'm quite interested in your comment about the specific court system in Switzerland for arbitration, because it sounds quite like what Michael talked about for Ireland, how there's a specific arbitration judge. And I know here in the US, we face a lot of difficulty with this, and perhaps Sarah, you can comment on this about the vast number of different jurisdictions at a state level, as well as the different federal jurisdictions, and how they interact, and the difficulties caused by this conflict of jurisprudence.
Yeah, sure. And following up on your question about remote hearings, I just wanted to mention in Chicago, in our federal courts, we have a new local rule 80, which in addition, I agree with Doro, international arbitration was not really held up at all by issues related to COVID. It was a practice that relied on remote hearings prior to COVID and will continue to going forward. But what new local rule 80 does is basically streamlines arbitration procedures in the courts, similarly allowing for you can have remote hearings when you need to, if you have a motion to vacate an award or to confirm an award. Foreign lawyers can appear in court, and that includes lawyers from different states within the United States and from countries outside of the United States. So sort of bringing court-related arbitration procedures in line with what we more typically see in arbitration procedures themselves. So that's a recent development here in Chicago. California had adopted some years ago a similar rule with regard to foreign lawyers representing parties in arbitrations to help streamline things.
And California was previously quite strict about that, right?
It was unclear. There were some court precedents that just made it unclear whether or not a lawyer who wasn't barred in California could represent a party in a private arbitration in California, which caused people, to hesitate in choosing California as a jurisdiction. But there are now a statute was introduced that erased that issue, so that now you can confidently choose whatever counsel you want for your arbitrations and proceed comfortably forward. It is, and with the FAA, and particularly in the commercial context, even though we have these varying state jurisdictions, and just about every state now has its own arbitration act, what the FAA does is really erase those inconsistencies. Preemption applies, and the FAA is going to control. So there aren't that many instances where a state, even if you are in a state court trying to enforce or vacate an award, chances are the FAA is going to intervene and smooth out the law for you and streamline things even there. And if you don't mind, I do want to clarify one comment that I made earlier. Grant Kim pointed out I was unclear. In the US, you can arbitrate whether or not something is patentable. The difference between the US and Switzerland and Belgium is that resulting arbitration award is enforceable only against the parties. It is not enforceable outside of the parties.
Sarah, you mentioned the changing rules in Illinois that allow for out-of-state and indeed out-of-country lawyers to practice arbitration here or appear for arbitrations. Not to plug our jurisdiction here too much, but there are other developments. I'm wondering if you could talk about the Chicago International Arbitration Center, which is in the process of being launched.
Happy to. Yeah, so this is a development, I'll call it, the Chicago International Arbitration Center. There are a group of people here in Chicago that are raising funds in order to set up an international arbitration hearing center that will be able to support in-person and remote hearings, as well as to help build a community around international arbitration here. Javier Rubenstein has been taking the lead on this. He's at Keegan and Spalding, and lots of other Chicago area arbitrators and arbitration practitioners are involved as well. So they're working on funding at this phase, but very excited to launch and have a lot of support from the mayor, Lori Lightfoot. So looking forward to that launch as well.
And regarding arbitral institutions and facilities, Claire, I'm wondering if you could talk a little bit more about SVAMC, which you mentioned earlier, which is the Belgian Center for Arbitration and Mediation. All of us might be somewhat more familiar with the ICC for proceedings there, but I understand that's SVAMC is huge in Belgium and is really important to the arbitration community there.
Yes, and they have actually adapted very quickly as well to the pandemic, having adopted revisited their rules in, I think, July 2020, to clarify that hearings could take place virtually, and that the default rule for communications would be email. Also, something to mention about SVAMC is that they were, I believe, the first, or at least within the first institutions to adopt the practice of using a secure platform for communication between tribunal, institution, and parties, which is really important for cybersecurity. Otherwise, I mean, the SVAMC's rules are, straightforward. They're user friendly. They try to keep up to date, with developments in the arbitration community generally. But I wanted to, the cost system is like the ICC, so it's ad valorem as opposed to hourly based, like the LCIA, for example. And they also have terms of reference. So, but I wanted to mention this aspect about the pandemic and also the use of the platform, which is I know too many quite important for security and practicality.
And regarding arbitral institutions, Michael, you talked a lot, and you, I think, sold us on how Ireland is a great jurisdiction for as a seat for your arbitration. Given the competition from London and the well-developed jurisprudence and respect for the LCIA and other similar arbitral institutions there, Ireland is a smaller jurisdiction. If we are to advise clients to see their arbitration there, what institution should they be looking to? What sort of facilities are available? And as well, given that it is a smaller jurisdiction and Dublin is a smaller city than London or Paris, for example, are there cost benefits and other benefits or drawbacks for going to Dublin?
Sure, James. Yeah, I mean, in Ireland, we don't see ourselves as competition with London, for example. I mean, that would be unrealistic, or indeed with the other major jurisdictions like Switzerland or Stockholm or wherever. We see ourselves very much as complementary to those jurisdictions, where for one reason or another, it may not be suitable to have the dispute there. For example, I was in a arbitration recently when, simply because of problems with COVID and traveling, it was an in-person hearing, people couldn't go to London for various reasons, depending on the jurisdictions they were coming from. And they managed to organize it that they could, in fact, come to Ireland instead. So there may be all sorts of different reasons why people would choose Ireland as a particular venue. In addition, I think we don't have an institution in the sense of a set of rules like the LCIA or the ICC. And again, it would be, in my view, totally pointless to try to set up such an institution, because there are arguably too many institutions in the arbitration world as it is, but certainly we're not going to add to it. But we do, for example, have Arbitration Ireland, which is the major arbitration association in Ireland. The first time we brought together practitioners in all fields in relation to arbitration, and it's proved a very successful organization. And if I could give it a little plug, we have an annual conference in November every year that has found its way into the diaries of some of the major practitioners in the world, because through an extraordinary fluke, we happened to have it on a Friday just before a rugby international. So that this year it's going to be held on Friday, the 18th of November, and Ireland are playing Australia in Lansdowne Road, the Aviva Stadium, the following day on Saturday, the 19th. So we have the conference, we have a very nice dinner in the King's Inns, and then we have the rugby international the next day, which I say just happens to be a coincidence. So we just approach the question of institutions in a slightly different way.
I'm putting that in my Outlook calendar right now. Look forward to seeing you there, Michael. We talked about earlier about how the UK is looking to reform the Arbitration Act 1996, but there is at least one other jurisdiction that's represented here today that in fact did reform their arbitration laws during the COVID pandemic, and perhaps may have taken account of the changes in technology and other changes brought about by the pandemic. So people familiar with Switzerland will know that arbitration law is governed by Chapter 12 of the Private International Law Act. So Dorothy, can you tell us a bit more about what changes happened with the 2021 reform?
Right. Yes. I think there were some general facelifts. I mean, the Arbitration Act is still really much state of the art, and it has always been very modern, liberal, and pro-arbitration, and very arbitration friendly. So the core aspects, and it's very much based on party autonomy. So a lot of that, none of that has changed. So there were just some clarifications in order to make it more user friendly. And there were a couple of changes that are actually very good news for many practitioners. And I just mentioned three of them here. The first big change for Switzerland was that challenges against arbitral awards that, as I said, go straight to the Swiss Supreme Court, they can now be filed in English. And that, of course, makes people's life a lot easier, because you don't have to now translate your whole case into one of the Swiss national languages. Now, that's a very welcome development. Then as a second change, Switzerland made arbitration clauses possible in unilateral legal instruments. So trust deeds or wills or articles of associations, you can now validly put an arbitration clause in there. And the third change that I find noteworthy is that the judicial assistance granted by the Swiss courts, because they're very supportive of arbitration. There's no interference, but a lot of support, especially with regard to taking of evidence and interim measures. And that support is now offered also to arbitrations that are seated outside of Switzerland. So that is something that is a very welcome development.
James, can I just jump in there on a slightly different point, but just going back to what you said about small jurisdictions and so on. I mean, it struck me, Singapore is a very good example, I think, to look at if you're a small jurisdiction trying to develop something. I mean, 25 years ago, there really was no international arbitration in Singapore worth the name. And yet they have managed to build themselves up to become one of the premier venues in Asia for arbitration. And they've done it through a mixture of good government support and government funding, pushing it very much at all levels of government. And in Ireland, we've set up an organization a couple of years ago with a view to promoting Ireland as an international legal center in the same way that we promoted ourselves as a financial services center. And we're trying to play to our strengths where we've got, you know, areas like aviation finance, tech, pharma, and so forth, which have huge presences in Ireland. And I think with a bit of that government support, apart from the other reasons I was talking about, a small jurisdiction like Ireland, looking at Singapore as a model, can certainly, I think, build itself up very successfully.
Sure, and we can really see that with the organization you talked about, Ireland for Law, which is supported by the Irish government. And in fact, John Bruton, the former Taoiseach and Prime Minister of Ireland, was appointed as head of that entity, which really shows how the Irish government is pushing Ireland as a place for arbitration. I'd like to shift gears slightly because, again, we're coming up on the hour mark. So I want to talk about discovery or disclosure in arbitration, given that we have people here from both civil law and common law jurisdictions, and there is quite a big cultural and legal difference between those two types of jurisdictions, with the civil law jurisdictions tending to favor as little discovery or disclosure as possible, and then the US being on the extreme end of the common law side with everything but the kitchen sink being produced in litigation. Sarah, I know there are ongoing developments in US jurisprudence on this, or on rather the question of discovery from US entities to aid with foreign arbitration and foreign legal proceedings. Can you tell us what's happening at the Supreme Court on this issue?
Yeah, I think we remain on the edge of our seats waiting for the Supreme Court to resolve this issue for us. This is related to the 1782 section code, where I have made a number of predictions over the last 2 years that, you know, they were definitely going to decide this issue for us this term. So I've stopped making any such predictions, and the issue still remains. But it's, you know, boiling it down to its sort of most basic framing. There is a question as to whether or not parties in a private arbitration that is outside of the United States can have access to discovery from witnesses and documents inside of the United States, based on some arguably ambiguous or allegedly ambiguous code language. And if the answer to that question is yes, it'll give parties some ability to basically eschew the Hague Convention framework on this. And if the answer is no, then it'll be cut off. It is a decades-long circuit split that has been developed in the United States, and frankly has resulted in some absurd results where there were multiple petitions for this discovery filed in a single arbitration. They were filed in different circuits, and it resulted in different results. So one petition was granted and one wasn't, which normally those are the kinds of circuit splits that the Supreme Court likes to eliminate. You know, they don't like absurd and inconsistent results like that happening throughout the circuits. It's a commercial issue that is not, not a salacious issue. I think we all thought that after the Kavanaugh appointment, the Supreme Court would be happy to take up an issue like this, since it isn't, it's not a hot button topic that was going to result in a lot of headlines that would make us arbitration practitioners very happy just to get resolution on it. But they have yet to do so. There are, the issue continues to percolate with them. I think we're all hoping that they take it up. And I think at this point, most practitioners, both inside of the United States and outside, just want the issue resolved so that there's clarity about whether or not these petitions are allowable in private arbitrations or they're not. So we kind of know what to do and know how to advise our clients. It's really difficult under the current framework. It's pretty difficult to give your client certain advice on this point, just because the case law is so all over the place. So I think we continue to hope that the Supreme Court will bring us resolution on this point, if not this term, soon.
Sure, and the Supreme Court certainly hasn't avoided the headlines recently. Here in the US, I guess the benefit of arbitration is US discovery is just so broad, so it's so seemingly never ending that so many documents are produced. But even in arbitrations at times, because it's tend to be worked on by US lawyers with the US philosophy to what should be produced in a dispute. I'd like if some of the lawyers from civil law countries could chime in and perhaps educate those of us from common law jurisdictions about what tends to happen in arbitrations in your jurisdictions, what sort of stuff is produced, and what limits there may be on discovery or disclosure, or however you want to characterize that process.
So maybe I'll start. So maybe I'll start on France. So yeah. Discovery is available in France. And there are two ways to get discovery in France. First, you can go to the French judge that supports arbitration, called in French the juge d'appui, and he will help enforce the tribunal's discovery orders and tell the parties that they need to comply. So that's one. The second is that the parties can go directly to the court under what is called the Article 145 proceeding, which is the designation by the court of an expert who is in charge of overseeing the discovery. And so you would make an application to the court, you would explain what documents you want to get, why they are relevant. There would be a hearing before the French judge. And if the judge issues the order, then an expert will be appointed and will oversee the production of documents, the deposition or interview of witnesses, and you can get quite complete discovery as long as you can convince the French court that the documents and the discovery is relevant and is not a fishing expedition. So there's quite a bit of support, even in discovery, in this very civil law jurisdiction, which historically does not welcome discovery. And certainly in French courts, you don't get that kind of discovery from the courts when you are in a judicial proceeding. So this is quite an exceptional possibility for the parties to get discovery in aid of arbitration. And so much so that maybe we'll start calling Paris the Dublin of the continent, because it's such a friendly place to carry out your arbitrations.
Well, in Switzerland, I would say, I mean, in Switzerland, it's such a small country, there's hardly any domestic arbitration. So almost all of the arbitration is international. And the arbitration practitioners here, as I said earlier, they come from all over the world. So what has emerged in Switzerland is that we follow pretty much what's now considered to be international best practice, as is reflected in the IBA rules on the taking of evidence in international arbitration. So, and that was, devised as a kind of a compromise between the common law and the civil law system. So where you can ask not only for specific documents, but narrow categories or specific categories of documents, provided that they're relevant and also material for the outcome of the case. So not just, somehow relevant, but really material for the outcome. And that, you have the typical exceptions with regard to, privilege and confidentiality and all of that, and that you don't possess that they're not in your possession or not under your control. So the usual things, but that is handled very pragmatically. I mean, there would be court support by the Swiss courts in order to enforce orders. I've never seen it that was actually necessary. So typically you would just get the typical procedural order on document production that is, very much along the lines of international best practice, unless of course the parties agree on a different approach, or if they want something that's more resembling more civil law or more common law, that's perfectly fine. And the tribunal will take into account the background of the parties. But if there's no clear guidance by, that it's clearly a different standard applies, they would just follow international best practice.
Maybe I can just add, so the position is very similar to France and Switzerland, both in terms of the scope of disclosure or document production that one party can get in the arbitration, but also in terms of the support that parties can receive from the courts in Belgium. There's one I think unusual provision in the judicial code in Belgium, which is that it's Article 1700, paragraph 4. Not only the judge can the judge of first instance, the president of the competent court of first instance can assist with enforcing a tribunal order on disclosure, but also that judge can provide that there will be an astreinte, so some kind of penalty. So as if a party is not complying with that order, that party has to pay more and more each day until compliance.
That same remedy is available in France also, une astreinte, a daily penalty.
Switching to, oh, sorry, Michael, go ahead.
Well, sorry, I was just going to add that, I mean, the actual wording of the rules, they're not that hugely different between common law and civil law, the IBA guidelines and so forth. It's all about materiality and relevance. I think the solution is that arbitrators should just be far more ruthless than they are. They should just say, I'm just not satisfied that this is really relevant in the sense of probative. It's going to make a difference to the outcome. And they just should rule out loads and loads of disclosure requests, much more so than they do. But that's just my own personal view.
So Michael, isn't one of the reasons arbitrators do that? I suppose there are two reasons. One is that they simply don't take the time because they're not prepared. And I think we may all have seen that. And the second one is that they might be a little bit scared, sometimes even terrified of due process concerns. That is, culling the discovery requests could give rise after an award to a motion to set aside for violating the due process rights to parties under one jurisdiction or another to get discovery.
Oh, I think that's absolutely right, Alex. I think you've put your finger on it. And I mean, arbitrators, they, above all else, they hate being reversed because of some breach of due process and so forth. They feel it's damaging to their own reputation, damaging to the possibility of getting further appointments and so on. So they do run scared from that. And I mean, I agree with you. And it's hard to know what exactly the solution to that is. But I think your first point is the answer: preparation. If they understand the issues in the case well enough, then they should have more confidence to be able to say, actually, I really don't think this is relevant. You can be wrong. You can sometimes do the arbitration. Near the end, you realize there was maybe some category of documents that could have been useful and relevant that you ruled out. But I mean, that's life. You know, nothing is perfect.
I will say, even in the US, where we take a broader view of discovery, arbitrators do appear to be increasingly emboldened to cut out discovery, obviously with a very even hand, right? Like one deposition per side or no deposition per side. You're never going to see it like you get 3 and you get 5 or something like that. But even with documents, you do see arbitrators feeling more emboldened with respect to limiting discovery.
I would say this.
Oh, sorry.
I see this trend in England, but also in Belgium, where I think arbitrators are increasingly kind of bolder when, you know, and prepared effectively to reject document requests.
Do any of you think that we may need the arbitral institutions to adopt stricter rules, perhaps with clearer definitions regarding what may be required?
I mean, I think the IBA rules do a really good job of circumscribing the territory that, you know, we're all playing in. And as Michael says, it comes down to materiality and relevance. And I still see a lot of requests that are framed in terms of all documents. And, you know, almost your initial reaction should be to say, well, you just don't get that. You know, you don't get something that's expressed as broadly as that, end of. Because you really have to kind of force the practitioners to think more carefully about what they're asking for. But I do think what's interesting in the English court rules, in fact, is that, England historically had a relatively broad approach to the giving of document discovery in litigation proceedings. And in fact, because it got bigger and bigger and bigger and closer to, I think, the US model, the most recent iterations of the court rules have incorporated a range of types of disclosure, some of which actually look very similar to what the IBA rules do. So it's a perfect example in a way of good arbitral practice feeding back into a national court system in a way that actually does streamline the process and hopefully save the parties some cost.
And some of the institutions include presumptions. I think it's the ICDR that says, there's a presumption that, for example, written discovery isn't going to be allowed in an arbitration, and JAMS has a rule that, it's one deposition per side. I do think those presumptions help arbitrators reach conclusions where they can exclude things if there are stated presumptions like that, even if it's not a rule. It gives the arbitrator a basis to exclude discovery without being as scared of what the award, what's going to happen to the resulting award. And frankly, as a party, it gives me a basis to argue against discovery. If I can cite something in the rules, you're just far more likely to be successful.
I've been enjoying the discussion too much, so much so that I forgot to give the CLE code. So I'll give that now, because I know a lot of the US attendees definitely want that. You'll receive a form sometime after this panel discussion ends, and you'll be asked to put in a code. That code will be Arbitration 2022. Arbitration 2022. In our last couple of minutes, I'd like to address just one other developing topic. Here in the US, third-party funding or litigation finance has become big business. I know in some of the jurisdictions represented, for example, Ireland, it's a lot stricter. Ireland still has strict jurisprudence that goes back to the doctrines of maintenance and champerty in the Middle Ages. But I'm wondering how this business is developing elsewhere. Philip, I'm wondering if you could talk a little about the UK and whether this is becoming a new industry in the UK, like it is in the US.
Yep, and I think it's actually become almost mature now. I mean, when I started hearing from third-party funders, which is now more years ago than I'm prepared to admit to, there were maybe one or two in the market, but not more than that. And actually, it was more, there were funders who would buy awards and then go and try and enforce them elsewhere, rather than funding the cases as they went along. What we have now in London is a whole gamut of funders who range from entities that are funding law firm portfolios of cases, so that they're not looking at it on a case-by-case basis, which means that cases which wouldn't be funded on a one-time basis can now be done as part of the portfolio funding model. They're also themselves still buying up awards and seeking to enforce them. And there are smaller entrants in the market who are specifically looking to fund smaller commitments, smaller cases. But that proliferation of funders, I think, has had one very positive impact from the client side, which is that the cost of that funding is coming down because it's much more competitive than it used to be. Although you do still see some eye-watering multiples in terms of return on investment. But by and large, I think the funding model has increased access to justice in certain cases, but the funders themselves, because they are beholden to their own investors, they're not investing willy-nilly, they're certainly not throwing silly money at it, they're not enabling poor cases to be brought. But what they are doing is actually making a ton of money out of supporting cases that have real prospects of success to enable them to be done properly. And I think that as a development is a good thing overall from an English law perspective.
In our last minute or two, I'm wondering, because my knowledge of this regarding the civil law jurisdictions is quite limited, Alex, Dorothy, and Claire, is third-party funding available or permitted in your respective jurisdictions?
So I will address this quickly. In France, it is permitted. The issues that arise are mostly related to conflict of interest issues, and that is mostly dealt with by transparency. And so the French courts have taken the position that Third-party funding is okay, but there needs to be complete disclosure about who the funders are, what their parent companies are, who potentially their major investors are. So all of those relationships that could have an impact on conflict of interests need to be disclosed. And it's still a bit of a murky area. The case law is developing, but that is the direction France is going in.
Switzerland allows it. We don't have the same far-reaching transparency rules. There's hardly any regulation. There's some, details regarding the independence of counsel, but that can be dealt with by just some contract clauses to make sure the client and the counsel remain controlled. But other than that, it's more than the question of what has to be disclosed to the tribunal, and that's more a question of the arbitration rules. But Switzerland itself doesn't impose any major transparency.
It's similar, so it's permitted. So third-party funding is permitted in Belgium, although only just taking off right now. We have a decent sized and very popular funder based in Belgium called Demino, but Demino, they've been present in many other jurisdictions, and they're only starting to fund cases in Belgium, actually. So, so that's all I have to say about that.
And with that, we have ran out of time for our discussion. This has been a very broad topic that we've discussed today: comparative international arbitration. We've discussed 6 different jurisdictions at a very high level. I hope in the future we'll have a chance to pick some more specific topics regarding these 6 jurisdictions and dive in a little bit more, because this has been really interesting. I want to thank our attendees, the Silicon Valley Arbitration and Mediation Centre, Arbitration Ireland, and more importantly and more specifically, I really want to thank Philippa, Sarah, Dorothy, Alex, Michael, and Claire for your great contributions today and for the wonderful conversation. Thank you all so very much.
Thank you, James.
Thanks.
Yes, thank you, James. Thank you, everyone.